Hello everybody, today I'm going to be talking to you all about one of the most significant fundamental court cases in American history, Griswold versus Connecticut. Now, before I start to get into the details of this case and tell you why it's so important, I think it's necessary to mention that this case took place in 1965, which means people were far more old-fashioned than what we're used to seeing today. So if the main premise of this case sounds a little cuckoo crazy, it's mainly just because people at this point in time had very, very deeply rooted beliefs about what they thought was morally correct, and in some cases those beliefs were just a little crazy by today's standards. It's also important to note that during this time period there was a growing problem with women having unplanned pregnancies and access to safe abortions being extremely limited. This led to hundreds of women trying to perform extremely dangerous at-home abortions with sharp objects like coat hangers or sewing needles, or by doing things like drinking toxic chemicals like bleach or laundry detergent. So, now that we have some of the background information out of the way, we can start to get into the actual case. Now, this whole case began when a gynecologist from the Yale School of Medicine named C. Lee Buxton and the head of Planned Parenthood in Connecticut named Estelle Griswold opened a birth control clinic together in New Haven, Connecticut, in an effort to supply people with contraceptives so that they could cut down on both the amount of people having unplanned children that they do not want and the shocking number of women who were attempting to self-abort their unwanted children. However, soon after the facility opened, the two were arrested and convicted of violating a law that was put in place in 1873, which, among various other things, banned the use and distribution of all forms of contraceptives. And I just feel the need to reiterate that the law they were being arrested for breaking was made almost an entire century before their arrest, in 1873. I say this because I think the fact that they're being prosecuted for breaking this outdated ancient law is just representative of all the insane, ridiculous ways that people during this time period will go out of their way to try to make things harder for women to exercise their freedoms over their own bodies and get things like Planned Parenthood and birth control clinics shut down. But thankfully, the two women were both very well-educated and competent individuals who sought to lift the ban on contraceptives by challenging the constitutionality of the law in court. Because of this, the Supreme Court now had to answer the question: does the Constitution protect the right of marital privacy on a couple's ability to be counseled in the use of contraceptives? Or, in much more simple terms, does the Constitution give people the privacy to decide whether to use contraceptives on their own without government influence? Well, after reviewing this case, the Supreme Court decided with a 7-2 majority that although the right to privacy is never explicitly stated in the Constitution, it can be inferred from parts of the First, Third, Fourth, and Ninth Amendments that people have the right to privacy, and thus citizens have the right to marital privacy when deciding whether or not to use contraceptives, and so no state has the ability to enforce a ban on contraceptives. Two judges gave dissenting opinions on this case. Their names were Hugo Black and Potter Stewart, who both stated that the law, although completely ridiculous and a little vulgar, was completely constitutional, and that there were no provisions in the Constitution to support the case that the law was unconstitutional. Which just goes to show you that even the people who voted against the defendants in this case still felt that the law in question was outdated and ridiculous. And now I just want to talk about the lasting effects of this case. The precedent set by this case is still significant even today, 40 years later, as it continues to help pave the way for reproductive privacy and freedom over one's body for women all across the country. I feel like this case in particular is just a testament to the power of the United States legal system when it's in the hands of capable and driven people who want to see the U.S. citizens are afforded all of the rights promised to them in the Constitution. Luckily, the United States legal system did its job in this situation, because of all the efforts of Estelle Griswold and Ms. Lee Buxton, who selflessly worked and ensured that the people could be afforded their right to keep their use of contraceptives private and free from state control. It's interesting to see just how far we've come, because now we're at a point where it's crazy for most people to even imagine a law like that being put into place, let alone actually be enforced. And although we have come a long way from where we were in the 1960s, I think we're still seeing a lot of this same old, outdated thinking in the courts today in places like Texas. And things could easily go back if we're not careful, which is why the precedent set in cases like this can still be so significant, even all these years later. Well, thank you all for listening. I hope you gained a much deeper understanding of the Griswold vs. Connecticut case, and I hope that you do well on the assignment provided to go with it. Thank you very much. Have a great rest of your day.